In Florida, there is a presumption that the parent who is a victim of domestic violence has sole or ultimate decision-making authority. The court does not expect a victim to be able to have an open dialogue and mutually agree on decisions for your kids with the person that committed domestic violence. They don't. So instead of that shared 50-50 presumption for decision-making, the victim will have the presumption in favor of sole decision-making, meaning you can make the decisions for your kids without having to run it by your abuser. A protective order or injunction for protection against domestic violence is essentially a no-contact order. If you are a victim of domestic violence, you can ask the court to issue an order that gets the other person out of the home. This happens very, very quickly, often within a day or two of filing. If granted on a temporary basis, law enforcement will bring the order. They will show up and tell your spouse. They have about 15 to 20 minutes to pack what they need, and they will escort them off the premises. If your spouse violates that protective order, there is a very real chance that they are going to jail for violating that injunction. A temporary injunction can remain in place up to 15 days without a hearing, but there will be a hearing. At the hearing, you will have the opportunity to present evidence and testimony that shows that either you were the victim of domestic violence, or on the other side, you will have the opportunity to present evidence and testimony that shows that the other person either made it up to get the other hand in a custody battle, is completely fabricating the situation, is turning a small yelling incident into just blowing it completely out of proportion, or it didn't happen at all. If you are accused of domestic violence, just be aware that the judge has to make a decision without you ever getting in front of the judge, and they are typically going to rule on the side of caution and safety. Just know that even if you are removed from your home on a temporary injunction, you will have your day in court to defend your rights. Any debt, regardless of whose name it is in, that was incurred during the marriage. And when I say marriage, I'm talking about the wedding date to the filing date. Any debt at all between those two dates starts as a marital debt. That includes credit cards, mortgages, and yes, even student loans. To prove that they're not marital, we have to show that they're for a non-marital purpose, such as unnecessary plastic surgery that was just used to inflate the debt and was used to be more attractive to someone new that's not the spouse, or an exotic trip with a significant other that's not the spouse. Things like that the court will take in consideration. But just know the starting point is everything will be divided, including credit card debts, and it does not matter whose name it's in or who incurred the credit card debt. Everything is marital unless found otherwise. A prenuptial agreement can have a significant effect on divorce proceedings. A properly done prenup will often identify who gets what. It will classify property as either marital or non-marital. And there's often provisions in a prenup that if either spouse challenges the prenup, they have to pay for the other side's attorney's fees if they lose. Does this mean that all prenups are going to be considered valid? No, absolutely not. Was there full and complete disclosure? Did you even know what you were signing away? Were you handed the prenup on the eve of the wedding after your family flew in from all over the country, after the wedding venue was paid, after all these deposits were made for vendors? The court will look at the timeline of the prenup, the disclosure of the financial information, and other things as well. One thing about prenups is that you can never agree, even if you did, it doesn't mean anything, that each side will pay their own attorney's fees. The court will consider the tax effect of certain assets. So for example, if you have a tax liability that's during the marriage, it can be considered a marital liability. If you were a stay-at-home spouse who had no part, then we can plead for innocent spouse, meaning that the person that misrepresented income leading to this new tax liability can be fully with that person. The same is true of assets you get in a divorce. You cannot touch a 401k. You cannot touch a investment account without taxes, whether it's a capital gains tax or any other tax or fees like with early withdrawal of a 401k or other retirement account. those assets will be tax affected so long as there's competent substantial evidence to prove why they should be when they are being divided. In other words, a typical $100,000 in the bank is not worth the same as $100,000 in a 401k. They would typically be that $100,000 is worth about 80%, so $80,000. So if you're getting an $80,000 401k, the other side is getting $100,000 in an account, they would have to pay you $10,000 from that account to make it a net 90 grand for both of you.